So, hello, welcome everyone to Lazy Law. Let's begin Bnss 1000 MCQs series. Here is part 3. We start from question number 102. The word bail means release of a person accused of an offense is option A, and option B is release of a person suspected of commission of an offense. So here option C is correct, which is both A and B. Let's go to the question number 103. The word bail bond is defined in section 21D of Bnss. Question number 104. The word bond is defined in 21E of Bnss. The word bond means personal bond, an undertaking of release with surety, and undertaking for release without surety. And option D is both B and C. So option D is correct, which is B and D both. Question number 106. Cognizable offense under Bnss has been defined in option B 21Z. In a cognizable case under Bnss, the police has the authority to arrest without warrant. Option B, authority to investigate offense without permission of a magistrate. So option C is correct, both A and B. The word charge is defined in option 21F, section 21F. So option D is correct. The word charge means includes any head of charge when charge contains more heads than one. Includes single head of charge when the charge contains only one. So option C is correct, either A or B. 110. A previous formulation specific accusations made against a person is called a charge. The word complaint is defined in option B 21H. So option B is correct, section 21H of Bnss. The word complaint means any allegation made in writing to a magistrate, any allegation made only orally to a magistrate. Complaint does not include a police report. Option D is correct, so all of the above. The word electronic communication is defined in section 21I, so option D is correct. The word electronic communication means communication to any written verbal pictorial information by means of an electronic device including a telephone, mobile. Video content transmitted by means of electronic device including a telephone, mobile. Option C, video content transferred by means of electronic device including a telephone or mobile. Here all are correct, so option D is correct, all of the above. 115. High court is defined in section 21J, so option B is correct. High court means in relation to any state, the high court for that state. In relation to any union territory to which the jurisdiction of high court for a state has been extended by law, that high court. In relation to any other union territory, the highest court of criminal appeal for that territory other than Supreme Court of India. Here all of the options are correct, so option D is correct, all of the above. The word inquiry is defined in section 121K. Assertion. Inquiry precedes trial. Reason. Trial is the third stage of the criminal proceeding. So option B is correct. Here A and R both are true, and R is the correct explanation of the A. The word inquiry means option C, every inquiry other than a trial conducted under Bnss by a magistrate or court. The word investigation is defined in option C 21 L of Bnss. The word investigations means all the proceedings under Bnss for the collection of evidence conducted by the police officer or by any person authorized other than a magistrate who is authorized by a magistrate in this behalf. The word judicial proceeding is defined in option B 21M of Bnss. The word judicial proceeding means any proceeding in the course of which evidence is or may be legally taken on oath. The term local jurisdiction is defined in option C 21N. The term local jurisdiction means in relation to court or magistrate means the local area within the court or magistrate may exercise all or any of its or his power. The term non-cognizable offence is defined in option D 21O. The term non-cognizable offence means the term non-cognizable offence means an offence for which non-cognizable means in which a police officer has no authority to arrest without warrant, and an offence for which and non-cognizable means so option A is correct. In a non-cognizable case, the police has authority to investigate even so here neither do the investigate without order of the magistrate nor can arrest without the warrant. The term offence is defined in option B 21Q. The term offence means an act or omission made punishable by any law for time being in force. Any omission made punishable by any law for time being in force. Any act in respect of which complaint may be made under section 20 of the Capital Trespassing. So all options are correct. So option D is correct. All the above. The term officer in charge of police station is defined in option A is correct. 21R. The term officer in charge of a police station mean when the option is correct when the officer in charge of the police station is absent from the station house or unable from illness or other cause to perform his duty. The police officer present at the station house is next in rank of such police officer and is above the rank of constable. Question number 133. The term place is defined in option D is correct. 21S of Bnss. The term place means a house or building, tent, vehicle and a vessel. The term police report is defined in 21T. So option C is correct. The term police report means a report forwarded by a police officer to a magistrate under subsection 3 of 193, section 193. Police report means option C is correct. A report forwarded by police officer to a magistrate under section 193 clause 3 of Bnss. The term police station is defined in option B is correct. 1U. The term police station means any post or place declared generally or especially by a state government to be a police station and includes any local area specified by the state government in this behalf. The term public prosecutor is defined in section 21V. The term public prosecutor means any person appointed under section 18 and includes any person acting under direction of public prosecutor. The term subdivision is defined under 21W of Bnss. So option C is correct. The term subdivision means a subdivision of a district. The term summon case is defined in 21X. Summon case means a case relating to imprisonment which may extend to 2 years. Summon case means a case relating to an offence punishable with not exceeding 2 years imprisonment for a term not exceeding 2 years. The term summon case means a case relating to offence and not being a warrant case. The term victim is defined in option 2(1)(y), section 2(1)(y). The term victim, a person who has suffered any loss, injury caused by a reason of act or omission of caused person, includes the guardian or legal heirs of such victim. So option A is correct. Victim means and includes a person who has suffered any loss, injury caused by reason of the act or omission for which accused has been charged. Option B, his or her guardian. Option C, his or her legal heir. So here option D is correct. The term warrant case is defined option B 21Z. The term warrant case means option D all of the above. A case relating to an offence punishable with death. A case relating to an offence punishable with imprisonment for life. A case relating to an offence punishable with imprisonment for a term exceeding 2 years. Question number 153. An offence punishable with imprisonment for a term exceeding 2 years relates to warrant case. Warrant case related to an offence punishable with death penalty, life imprisonment, or imprisonment for more than 2 years. A case relating to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years is warrant case. On receipt of a complaint within the meaning of section 21H of Bnss, the magistrate has the jurisdiction to conduct an inquiry himself, has the jurisdiction to direct the police to investigate. So option C is correct, both A and B. Complaint means allegation in writing made by complainant that an unfair trade practice or restrictive trade practice has been adopted by any trader or service provider. The goods bought by him or agreed to be bought by him suffer from one or more defect. A trader of the service provider has charged for the goods or for the service mentioned in the complaint a price in excess of the price. So here all options are correct. So option D is correct, all the above. In a cognizable case, question 158. In a cognizable case under Bnss, the police will have all the powers to investigate, including a power to arrest without warrant. So question number 159. Non-cognizable offence has been defined in two O. So option D is correct. A case which includes cognizable offence and non-cognizable offence is a cognizable offence, and such investigation and such the investigation of the case does not require any sanction of magistrate under 174 clause 2 of Bnss. 161. A warrant has been defined under 21Z of Bnss as a case relating to an offence punishable with death, imprisonment for a life for a term. So option B is correct, exceeding 2 years. 162. Classification of summons case and warrant case. So option A and C are correct. So option D are correct. Is useful to determine the trial procedure to be adopted. Is useful to decide the question of issuance of a process to the accused. Question number 163. Complaint as provided in section 121H of Bnss. So option C is correct. Either in writing or oral. Complaint as provided under section 21H of Bnss must necessarily be a magistrate only. The complaint may relate to both A and B, cognizable and non-cognizable case offense. Question number 166. Which of the following is a requisite of a complaint? So all are correct. All are the requisites of the complaint. So option D is correct. 1, 2, 3, 4. An oral or a written allegation that some person knows or unknown has committed an offence. It must be made to a magistrate. It must be made with the object that he should take action. Question number 167. In respect of an investigation as provided under section 21L of Bnss, which of the following is incorrect? So option C is incorrect. Investigation can be conducted by magistrate himself. So option right answer is investigation can conducted by police officer. 168. Section 3 of Bnss is the result of which of the following? So option A is correct. Natural separation of the judiciary from the executive and allocations of the functions between the executive magistrate and the judicial magistrate made in the Sanhita. What does the subsection 2 of the subsection 3 of the Bnss lays down? Divides the function exercisable by the magistrate under the law other than Bharatiya Nagrik Social Sanhita into judicial and administrative or executive functions in clause A and B, and entrusts exercise of these functions respectively by the judicial magistrate and executive magistrate. Question number 170. When a complaint is presented to a magistrate, the magistrate proceeds to examination the complainant and witnesses. So option B and C are correct. So option D is correct. The magistrate is conducting an inquiry. Magistrate is conducting a trial. In bailable offence, no condition can be imposed while granting bail by the police officer or by the court. Question number 172. Which of the following the word any law in section 4 clause 2 of Bnss did not cover? So contempt of a kind punishable summarily by High Court and Supreme Court. 173. Which of the following section of 5 of Bnss will not affect? Section 5 of Bnss will not affect any special law, any local law, any special jurisdiction or power, any special form of procedure. All are correct. So let's begin chapter 2. Criminal Code and Offences. Offices. Chapter 2. Constitution of Criminal Courts and Offices. So question number 174. Which of the following section 8 of the Bnss does not provide? There shall be only one place where the session judge should hold its sitting. Section 10 of Bnss provides for appointment of Chief Judicial Magistrate, Additional Judicial Magistrate and Subdivisional Magistrate. All are one only, not session judge. What does subsection 4 of section 4 of Bnss lays down, divides the functions exercisable by the magistrate under any law other than Bnss into judicial and administrative or executive function in else A and B, and interest exercise of these functions respectively by judicial magistrate and executive magistrate. 177. Section 12 and Section 13 of Bnss provide for which of the following: the authority to take cognizance of any offence committed anywhere within the limits of an area assigned to a subordinate judicial magistrate. Which of the following, question number 178, which of the following pairs are correctly matched? Here, classes of criminal courts is given in section 6, courts of session is given in section 8, territorial divisions is given in section 7, and court of judicial magistrate is given in section 9. So option A is correct. Courts, classes of criminal courts is given in 6, territorial divisions is given in 7, court of sessions is given in 8, courts of judicial magistrate is given in 9. So option A is correct. Which of the following pairs are correctly matched? Let's see question number 179. So special judicial magistrates is given in 11, chief judicial magistrate is given in 10, local jurisdiction of judicial magistrate is given in 12, subordination of judicial magistrates is given in 13. So option B is correct. Question number 180. Which of the following is a classification of for criminal courts? Court of session is there, judicial magistrate first class and judicial magistrate second class is there, executive magistrate is there. So all are there. So option D is correct. 1, 2, 3, 4. Section 16 of Bnss confers that a magistrate appointed to act as a magistrate has, unless his powers have been restricted to a certain local area, jurisdiction over the entire district. Question number 182. In cases where an inquiry, trial, or other proceedings has been conducted in a wrong place, the inquiry, trial, or other proceedings cannot be set aside as void unless it has occasioned in failure of justice. Question number 183. Objection as to lack of territorial jurisdiction of the criminal court can be taken before or at the time of commencement of the trial. Under the scheme of Bnss, the original jurisdiction to take cognizance of an offence is vested in the court of magistrate. Question number 185. Who has the authority to establish a court of session in a district? So state government has the authority. Question number 186. Who will appoint the chief judicial magistrate in a district? High Court has power to appoint the chief judicial magistrate. 187. The presiding officer of a magistrate court is appointed by the High Court. High Court has the power to appoint court appoint court magistrate. Appoint magistrate in a court. An assistant session judge is appointed by High Court of the concerned state. The local jurisdiction of judicial magistrate is under the control of Chief Judicial Magistrate and High Court. So option D. Sorry, Chief Judicial Magistrate is correct answer. No person can be appointed public prosecutor for a district unless his name is in the list prepared by district magistrate. The experience required to be appointed as a special public prosecutor is 10 years. Public prosecutor is appointed by state government. Director of prosecution shall function under the administrative control of the head of the home department in the state. Question number 194. Which of the following is the highest criminal court in India? High courts. High court. 195. Which of the following pairs are correctly matched? So you can see options here. Executive magistrate, as we all know, 14. Subordination of executive magistrate, it is given in 17. Local jurisdiction of executive magistrate is given in 16. Special executive magistrate is given 15. So here 2, 1, 4, 3. So option B is correct. Section 17 of Bnss confers that. So option D is correct, none of the above. Question number 197. Which of the following pairs are correctly matched? So public prosecutor is defined in section 18. Assistant public prosecutor is defined in 19. Directorate of prosecution is defined in 20. Code by which offences are triable is defined in 21. 18, 19, 20, 21. So 2, 1, 4, 3. Option B is correct. As per the section 19 of Bnss, which one of the following is true? State government shall appoint in every district one or more assistant public prosecutor for conducting prosecution in court of magistrate. The state government shall appoint. The state government shall appoint in every district one or more public prosecutor for conducting prosecution in court of magistrate. Option C. The state government shall appoint in every district one or more assistant magistrate for conducting prosecutions in court of magistrate. Option D. The state government shall appoint in every district one or more advocate general for conducting prosecution in court of magistrate. So here option A is correct. The state government shall appoint in every district one or more assistant public prosecutors for conducting the prosecutions in the court of magistrates. Question number 199. Under which criteria a police officer cannot be appointed as an assistant public prosecutor as per section 19? So here option D is correct. The police officer has been part of the investigation of an offence in any way. The police officer is below in the rank of the inspector. Question number 200. Under section 220 clause 8 of Bnss, the power and functions of the deputy director of prosecution shall be to examine and scrutinize police reports and monitor the cases in which offences are punishable. So option A is correct, 7 years or more but less than 10 years. Question number 201. Under section 20 clause 9 of Bnss, the function of assistant director of prosecutions shall be to monitor cases in which offences are punishable. Option C, less than 7 years. Deputy has power 7 years or more. Assistant has power less than 7 years. Appointment of assistant director of prosecution is defined in 20 clause 2 subclause B of Bnss. Thank you everyone.